Thank you very much, Andrew, and thank you for asking me to do this. It's a hugely important topic, and as you said, it's a perfect backdrop for going to see Magna Carta shortly. Events in Paris a few weeks ago threw into very sharp focus this whole issue of freedom of expression. Here in Europe, something that we took and perhaps still take for granted was suddenly under attack. It's long been held that freedom of expression and freedom of speech are the most fundamental human right. Winston Churchill, who was much on our mind last week, said that it was the unsleeping guardian of all other rights. Without it, independence of the judiciary, freedom of worship, right to fair trial, and all others fail. That's why it's in Article 19 of the UN's Universal Declaration of Human Rights. That's why it's in the European Convention on Human Rights. And that's why it's in Article 5 of the Commonwealth Charter, which states that we are committed to peaceful, open dialogue and the free flow of information, including through a free and responsible media. And therein lies the issue, those words, free and responsible media, with the implication that to be allowed to maintain its freedoms, the media must also be responsible. It's an issue which has dominated much debate over the last few years in the United Kingdom. But who decrees what is responsible? How as a society do we deal with the problems that are raised by freedom of expression, for instance, with hate speech or with those who propagate terrorism? How do we deal with the internet and the huge explosion of content, much of which cannot be controlled by law or by self-regulation? What example has it set to emerging or young democracies in the Commonwealth when established ones like the United States or the United Kingdom curb a free press through legislation? For instance, here through the use of anti-terrorist powers to pry on journalistic sources. And what are the leadership role of the Commonwealth, both in ensuring the spread of free media and press freedom in countries where it's not properly established, at the same time as it's ensuring that it is responsible? All these issues and many more are going to be addressed in our session this afternoon, and we have a remarkably erudite panel to deal with these matters. And we're going to kick off, if we could, through Deputy Speaker Bruce Scott, who has a long background in these matters and importantly now is a member of the committee in the Australian Parliament on Intelligence and Security and has been on the Foreign Affairs Committee. Deputy Speaker, would you kick off?
Well, Lord Black, thank you very much for that introduction and, of course, to other panel members this afternoon, to delegates to this very important CPA conference here in London. I acknowledge you, and also my colleague from Australia, Senator Gavin Marshall, the Deputy President, indeed, from our upper house, the Senate, in Australia. And, of course, I want to also acknowledge Madam Speaker from the Parliament of Bangladesh. Congratulate you on your elevation and election to the chair of the CPA and some important work that I know you'll be doing. And we as Australia certainly look forward to working with you, as we have always with the CPA. It is, I think, an important moment in the history of democracies around the world that we are here also to celebrate the 800th anniversary of that signing of that wonderful document, the Magna Carta. I was only thinking perhaps it has been just as important in the Common Era, perhaps as Rosetta Stone was prior to the Common Era, in what it says and what it has been able to give us a platform in relation to constitutions and fundamental rights that formed that Magna Carta signed so long ago. I'd just like to give you a little bit of a backdrop about Australia, because we are an island nation surrounded by an enormous moat. So in many ways we sit way down in the Southern Ocean there with the Pacific, the Indian and the Antarctic Ocean below us, and of course the Timor Sea and countries to our north. But it wasn't until 1901 that the states had agreed through a referendum to come together to form the Commonwealth of Australia, the Federation of Australia. And it wasn't until 1901 that Australia had the Commonwealth with its own constitution. Mind you that all our states, the 6 states, have their own constitution, which is very interesting because they, from time to time, disagree with the Commonwealth on some issues, but it's the nature of how our Commonwealth and our federal government came about. At the time of the Constitution being established and the Commonwealth of Australia in 1901, we were largely an Anglo-Celtic nation. We'd come mainly from the United Kingdom, England, Scotland, Wales, Ireland, and over time our whole nature of our population has changed, and I'll touch a little bit on that because that raises some of the issues in relation to racial harmony. We were 4.8 million people when we came together in 1901 as united in one in the Commonwealth. Can I just go on to say that the Australian government is deeply committed to its freedom agenda, which includes advancing measures to protect freedom of speech, freedom of religion and other traditional rights and liberties. And the government believes that freedom of thought, conscience and expression is intrinsically valuable and desirable, and that every person has a right to express their views. Freedom of speech is a fundamental human right and a common law right in Australia. The Australian common law protects freedom of speech in many forms, including written and oral communication, public protest, broadcasting, artistic works and advertising. The common law protects this right to the extent that the presumption that fundamental rights should not be infringed can inform the construction and characterisation of legislation. Now, Australian common law provides particularly strong protections for freedom of speech related to public affairs and public matters. The High Court of Australia has also held that the freedom of communication of political matters is protected by the Commonwealth's Constitution as matters which go to the efficacy of Australia's system of representative government. Now, since coming into government and into office, I should say, in September of 2013, the Australian government, of which I'm a member of the party, the Liberal National Party that came to government, the government has taken some key steps to ensure that the fundamental right and freedoms are protected and promoted within Australia. First, the government committed to reforming the Australian Human Rights Commission to ensure that it gives appropriate weight to civil and political rights, in addition to its anti-discrimination and other advocacy work. In many ways, it was about getting the balance between those two rights, getting them rebalanced. And in February last year, the Attorney-General, Senator the Honourable George Brandis, appointed Mr Tim Wilson of the Human Rights Commission, of the Australian Human Rights Commission, to better balance the promotion of traditional common law rights and civil and political rights with the Commission's other work. The government has also sought to address the erosion of fundamental common law rights and freedoms by undertaking a thorough review of the Commonwealth laws which may encroach on these rights and freedoms. In late 2013, the government directed the Australian Law Reform Commission to review Commonwealth statute books to determine whether departures from those traditional rights and privileges had been appropriately justified, and it's due to report at the end of this year. But what particularly has been of interest, I know, in Australia, and of course at recent events in Paris and including in Australia, some very tragic circumstances related to, I think, related to terrorism and also to people's fundamental freedoms, particularly in expression, being the subject of attack. And in Australia, we have, under the Racial Discrimination Act, which was established in 1975, a section called 18C. I just want to point out that in 1975, we were a country, after coming from 4.8 million people in 1901, by 1975 we were a country of 13.5 million people. And the Racial Discrimination Act of 1975, Section 18C, makes it unlawful to do a public act that is reasonably likely to offend, insult, humiliate or intimidate a person because of their race, colour or national or ethnic origins. Now, whilst this provision is primarily designed to deter and punish acts of racial vilification, it imposes some limits on the freedom of speech. And in March last year, 2014, the government proposed changes to Section 18C to prevent the erosion of the right to freedom of speech, to focus on acts which are likely to cause fear and incite hatred, rather than acts which are likely to cause offence only. Now, at the time, following consultation, because as part of the process the government called for submissions across the country, and we received over 5,000 submissions on this proposed legislation. Following the consultation, the Prime Minister decided that protecting the community and social harmony, particularly in the context of the current national security threat, that should take priority over other considerations, including reforming Section 18C. And as a result, any proposal to reform Section 18C of the Racial Discrimination Act has been basically set aside and will not proceed. I mentioned that our security threat level at the end of last year had been raised to high, and it remains at high level now, something that in Australia, for Australians, we were not used to having a security threat at that level, and I think it's many, many decades since we've seen such a situation in relation to security within Australia. Now, what this highlights is the nature of Section 18C to not curtail or restrain. It is a question of balance. And it is important to look at our laws against the heightened security level in Australia right now. We are dealing with a number of Australians who have been radicalised and have joined ISIS. And we are going through a process right now with other legislation to see how we can de-radicalise those Australians that have been radicalised and are known to be domiciled still in Australia. And that is why we are working very hard with the existing laws to ensure harmony and at the same time protect our community. Harmony really is about people of different race, religion and gender living together peacefully and harmoniously. Now, Section 18C has received renewed media coverage in early this year, 2015, at the end of last year too, in light of the situation in Paris with Charlie Hebdo, the cartoon and attacks which occurred in Paris. In response to these events, the government in Australia has reaffirmed the view that it is the responsibility of the relevant publishers to ensure that any publication of the cartoons complies with Australian law. The Australian government remains committed to protecting the right of all people to express their views, including people with controversial views, but they must remain within the framework of Australian law. Now, whilst the Australian government will not support reforms to Section 18C, there are exemptions that are provided for under that legislation under Section 18D of the Act. And we do, however, remain committed to the protection and promotion of freedom of speech. Now, Section 18D has not had the exposure in the media that Section 18C has, because Section 18D does provide for exemptions. And I'll just read you some of the that clause in the legislation. Section 18D states that we do not render unlawful anything said or done reasonably and in good faith. It goes on that in the performance, the exhibition or distribution of an artistic work, or in the course of any statement, publication, discussion or debate, made or held for any genuine academic, artistic or scientific purpose, or any other genuine purpose in the public interest, or by making or publishing a fair or accurate report of any event or matter of public interest, or a fair comment on any event or matter of public interest. So if the comment is an expression of a genuine belief held by the person making the comment, so it is important that when we look at 18C, we look at the exemptions, and I know they sound complex, but they are there in the legislation under 18D. The Australian Government is continuing to work to reform the Australian Human Rights Commission and to ensure that it appropriately focuses on civil and political rights and fundamental freedoms. The Australian Government is also looking ahead to the release of the Australian Law Reforms Commission final paper in the middle of the year, which will help guide our thinking and how encroachments into civil and political rights across a far broader range of statutes might be addressed. In conclusion, I think we could probably all agree for legislators at the moment it is very difficult to look at some of the issues in isolation, and this is the case in Australia. Australia now has a population of 23.1 million people. 114 years ago, we had a population of 4.8 million people, made up primarily of migration from the United Kingdom. Today, of those 23 million, 6.2 million, almost 25%, were not born in Australia. And I think that helps you focus a little bit on the complexity and the multicultural, multi-ethnic, multi-religious makeup of our Australian population today. And our constitution, the foundation of every constitution, was built on the backdrop of the Magna Carta. And it is celebrated. I think, if I could just use a couple of terms that I think describe what it is to be an Australian. Against that backdrop of 23.1 million people today, 25% of whom were not born in Australia, that we are a nation that celebrates our place in the world and within Australia with the words of mateship and a fair go. And in the UK, I think every now and then we think we just want a fair go with the Ashes test when you're preparing those pitches, but for the forthcoming cricket round. But can I just say, when we associate the word mateship, we associate it with families, friends, teammates, and those who share with us in times of sadness and joy. Often these people are strangers to us, but the word mateship is an important word in our lexicon in Australia. A fair go, and that's what so often we talk about, a fair go for all. And I know my colleague could share that with me. It is fundamental for us all, and sometimes we see situations where there is not a fair go, but a fair go is very much part of the makeup of Australia. A fair go for all, for young and old, regardless of race, of religion, gender, or other rights and liberties. I want to leave you some other words because I think it is important, as I said, that our makeup of our Australian population is vastly different from when the Constitution was originally drafted. Throughout the last 114 years, legislation has been brought forward to ensure that we continue to advance our role in protecting rights and freedoms and civil liberties for all our people. We have a national anthem which I says so much about us, and that is that Advance Australia Fair. We And I think it is an anthem that says a great deal about us, where we come from and where we are in the world. Australians, all let us rejoice, for we are young and free. But I often think there's a people's anthem, and the words to a song that were written in 1987 that says a lot about Australia, our culture, because I think our constitution, which derives so much of its wording and clauses in it from the Magna Carta, I think so much of that has built our national character. And I'll give you these words. We are one, but we are many, and from all the lands on earth we come. We share a dream, and we sing with one voice. I am, you are, we are Australian. Thank you very much.
Thank you so much for that. I'm not sure I can help with the ashes, but that was a fascinating case study to kick us off of how the law sometimes needs to be balanced, or can be balanced, to deal with the security situation. Our next speaker, I take from his CV, is both journalist, author, advocate and campaigner. That might be a good summary of it. Steve Crawshaw is Director of the Office of the Secretary-General of Amnesty International, where he's been since 2010, and he's going to look in particular at the role of international organisations in this area. Steve, thank you very much.
Thanks very much indeed, and thank you for the invitation for Amnesty International to speak here today. As you say, the issue of freedom of expression is clearly central for Amnesty International from its very birth, really, 50 years ago, 1961. Many of you may know the story of how it got created. Peter Benenson, the founder of the organisation, who read the small news story, the tiny buried news story of two Portuguese students raising a toast to freedom under the military regime of Salazar in Portugal, being arrested and jailed for that, and his outrage at that and feeling what could people around the world do to confront that. That was the seed that gave birth to Amnesty International. And although we've spread in so many different ways, the idea of the prisoner of conscience, which was at the heart from the start and was the word that Benenson Amnesty created at that time, is clearly important, and freedom of expression so often is a key part of the reason why Amnesty International prisoners of conscience and other human rights defenders have ended up behind jail, simply for, frankly, to use the old phrase, speaking truth to power. And I hope that we would all acknowledge that speaking truth to power, those truths are what help to create stability, although sometimes we hear the worrying narrative that it's the opposite, that speaking those truths is what gets difficult. People find themselves locked up simply for speaking the truth. Clearly, this theme is of particular burning relevance in terms of what we've seen in recent weeks and months, the attacks on Paris, which have already been mentioned at the back of our minds so much, where fundamentally people were murdered simply because they had exercised their right to freedom of expressions. The cartoonists who had never shown any inclination to violence, and who crucially were not inciting hate against others also, but were disrespectful, as is the job of cartoonists worldwide, were disrespectful globally. And so on the one hand, we see the killing that happened and the outrage. I think that all of us were outraged on that. But we then had two kind of problems that came off the back of that, if you like. On the one hand, there were those who spoke up for freedom of expression when it came to those who had been killed there, but curiously were not so bothered, including government leaders, were not so bothered about lack of freedom of expression in their own countries. In other words, an asymmetry, to put it politely, in that respect. And also troubling, in at least a small way, but also in a sense in a serious way, was that you had side by side with the correct outrage at these murders because of the cause of freedom of expression, At the same time, you had arrests taking place in France immediately afterwards under the law of apology for terrorism, apologie du terrorisme. And that law was used to arrest people, for example, who originally were just on a tram, on a bus without the right ticket, but then said the wrong thing and were then arrested for that. So that's really a worrying misuse, I think it's fair to say, that you really need to think about what does it mean. Anti-terror legislation is used around the world in very dismaying ways as a way of suffocating freedom of expression, and it shouldn't be like that. Hate speech is an enormously important theme, which we will no doubt continue to speak about during this session, and we have seen many, many occasions over the years when hate speech has wrongly not been confronted. But I think that it's very important to make a distinction in one's mind between hate speech which genuinely incites violence, and crucially, some of my examples I will come into a moment will deal with this, what one might call hate actions, which result from hate speech. That's when it actually matters, is when something has happened directly because of people stoking hatred against others. And too often we see that, in fact, even those places that clamp down on freedom of expression issues, when there are actual physical attacks on other ethnic groups, others in their own country, others of different beliefs, of whatever kinds it may be, at that point the government is often wrongly standing back and is failing to prosecute. In other words, we need to address that culture of impunity that we see. A couple of current examples where we're seeing the worrying disconnect that Amnesty International is particularly concerned about. First, a couple which are not from Commonwealth countries. Raif Badawi, I hope that many of you will be, or most will be aware of the case there in Saudi Arabia. There's somebody who spoke out, simply was speaking out as a human rights defender, saying some basic truths, finds himself arrested, jailed for that, and then flogged and 1,000 lashes. As it happens, those whippings have been now postponed 3 times, I think it is now, perhaps partly because of the world's outrage, but they are still on the books, if you like. There we have just one emblematic example of the absolute clamping down on freedom of expression, which does not give stability, it gives the opposite. Another case would be still in the same region, Bahrain, Nabil Rajab, who I met last year when he came to Amnesty International in London to give thanks for our speaking out on his behalf when he had been in jail previously, rearrested. His fault was to suggest that the behaviour of the security services was itself helping to create instability, and that those who were in ISIS had come from that. He got arrested again for speaking truth to power. He must clearly be released. And Raif Badawi must clearly be released. And as I was arriving here today, I was seeing the latest, which sadly is from a country in the world, a member state of the Commonwealth. In Malaysia, we understand that there's been arrest there of a human rights lawyer who again was arrested really just for speaking out against extremism, but in a way that the government didn't wish. And certainly if he is jailed under the colonial era Sedition Act, as it's called, we would certainly see him as a prisoner of conscience. And that's just one of a number who have been arrested. It's a pattern that we're seeing in far too many places. I will focus on a couple of examples on Sri Lanka as a member state. I don't wish to single out Sri Lanka specifically because it's the only place where bad things have happened, but I think it does become an emblematic example of all of the things that we are talking about. And the new government that is recently arrived there, I welcome the fact, Amnesty International welcomes the fact that we are hearing strong, more positive signals for the future, and I hope that we will see that. Actions, of course, do matter much more than or even more than the signals. Those signals are an important start. The dangers of hate speech, very clearly visible. We see the Buddhist nationalist organization, Bodu Bala Sena, BBS, who were making hate-filled speeches in Sri Lanka. As a direct result of that, there was an outbreak of very serious violence in which 4 people were killed and dozens were injured. This was in during 2014. And what we saw was that those who had been doing the incitement did not get punished in any way, despite the fact it had such lethal impact. But you also found that the media who wished to write about what had happened were themselves told they must not write. So you have a double misuse, if you like. The hate speech is not being sufficiently addressed in connection with the hate actions that were caused by it, and yet you do see a suffocating of the oxygen, if you like, of any free society, which is deeply worrying. And we also see that there are threatening pressures on those who do dare to speak out and criticism. So the Prevention of Terrorism Act, the same kind of legislation which again is worryingly used and misused in too many countries around the world. And the magnificent human rights defender, Ruki Fernando, who I met when I was in Sri Lanka last year, sorry, not last year, during the Commonwealth Heads of Government meeting in 2013, he himself repeatedly, and many others, received very severe threats against him, including most recently, before the most recent elections, severed dogs' heads put out, a dog head outside his home and the home of a colleague as an obvious death threat. Others have actually been murdered, like the Sri Lankan newspaper editor Lasantha Wickrematunge, who in effect wrote what one might call the chronicle of a murder foretold. He wrote about what would happen when he would be murdered for the fact that his newspaper dared to speak the truth. And that piece that he wrote was then later published after he had actually died. But he said important things which are valid not just for Sri Lanka, but all around the world. The free media serves as a mirror in which the public can see itself, sans mascara and styling gel. From us, the media, you learn the state of your nation, especially its management by the people you elected to give your children a better future. The image may not be a pleasant one, but while you may grumble, or in the privacy of your armchair, the journalists who hold the mirror up do so publicly and at great risk to themselves. That's our calling, and we don't shirk it. And then it ends chillingly. When finally I am killed, it will be the government that kills me. In the wake of my death, I know you will make all the usual sanctimonious noises, call upon the police, but like all the inquiries you have ordered in the past, nothing will come of this one too. And so it goes on. And he was right, that fundamentally there's been much too little investigation. Still less of Pragith Eknaligoda, the cartoonist and journalist who was forcibly disappeared 5 years ago, and Amnesty International is campaigning strongly for investigations, the end of impunity on that. Many, many other examples. I say I focused on that one country simply because the problems have been very grave and the question of impunity had been so grave. But fundamentally, those are problems that we see all around the world and in far too many contexts. So what do we need to see? We need to see the repeal of anti-terror legislation which picks up into its net not those who are genuinely endangering the country, but on the contrary simply those who dare to speak out about the problems that they see in the country. And as Wickrematunge rightly said, that will sometimes be painful for the rulers, but in the bigger picture, that is what brings the stability of the country, and that is why it is so important. I've been asked to address what human rights organizations can do in terms of working out how not to increase the danger, if you like, that individual human rights defenders and those who speak out are going through. Because in a sense, by working with them, there are dangers associated with that as well. The simple answer to that, I think, is that there is no simple answer. Perhaps the first part of my answer would be that it's not really possible for us to make the decisions that the people, the enormously courageous people that we are working with all around the world and in many different Commonwealth countries are making their own decisions, showing enormous courage in what they do. And we have to respect that courage. We may talk to them saying, are you sure you want to do that? Is that not too dangerous? But at the end of the day, they are the ones who are making decisions, and we must, in a sense, stay out of that and only give the support that we can for whatever decisions they are making, which are extraordinarily brave, and I am constantly in awe of the courage of the people that we are dealing with. And these human rights defenders, they, in a sense, from Amnesty International's perspective, they have two roles. They are both key actors themselves in creating human rights change in their own country, in their regions, and around the world. And at the same time, of course, they are sometimes the subjects of Amnesty International's work. When they themselves become arrested or disappear, they become prisoners of conscience or others who we campaign for. In as much as we are able to mitigate the risks, then clearly secure communications, which all of us, I'm sure, are thinking of the whole time, is essential. That was in some ways easier in the old days, but in some ways more difficult. You were smuggling handwritten notes only. Now there is much technology which can to some extent bring us opportunities through encrypt, never mind, well, we do mind, on the one hand through being able to encrypt and somehow being able to communicate safely, but on the other hand we are constantly aware, as all of us in this room are aware, that powerful governments and those powerful governments' friends are able to do surveillance on pretty much anything that is put into electronic writing. And so clearly that concern is massive, but is one that we are thinking of. You won't be surprised to hear very significantly because of our communications with those human rights defenders, which are so sensitive. I think perhaps the one that we do, which is perhaps most important, is the sense of consultation and listening. It's not really for the global organization, be it Amnesty International or any of the other global human rights organizations, to have a view on exactly what should happen. We are listening and consulting. We will do consultations both inside the country and outside the country, depending on the security issues, and talk things through and talk the problems. Above all, then, to sum up, I do think that the one thing we cannot do, that none of us can do, is to stand back from the gravity of freedom of expression issues today. This is literally a life and death issue for many of the people that we are dealing with. They are showing such extraordinary courage in putting their head above the parapets. And sometimes they have, as described a moment ago, and you will be aware of many other examples, have paid for this with their lives. But it's also, I would argue, a matter of life and death in a sense for all of us. We're living in an insecure world. None of us needs to know that. None of us needs to be told that today. I think it needs to be understood that freedom of expression is not part of the problem. It is part of the solution. If we are speaking truths constantly, and also if we are ending the impunity for crimes committed in the past, in other words, hearing truths spoken in a different kind of way, that is what can help create the more secure world. It's not just a moral issue, although it is certainly also a moral issue as well. Above all, it is how to create a more secure world. And I thank you for listening to me. Thank you.
Thank you very much for that, Steve. A very timely reminder of how the use of anti-terror legislation, in your very powerful word, I thought, suffocates freedom of expression, and indeed the way that clamping down on freedom of expression can actually breed instability. It is, as you say, a very grave situation. Just before I introduce our last speaker, I must in advance give you an apology that I have to speak in the debate which begins at 2:45 on an aspect of media freedom. As I gave up running some years ago, I will probably have to leave just a little bit before that, and Andrew will finish the session. Our last speaker, Henry Maina, has a long and distinguished track record and career in human rights, going back many years, has been at Article 19 since 2008, and he's going to look for us at the role of freedom of speech and freedom of the press in maintaining a functioning democracy. Henry, thank you.
Thanks so much, and quite honored to be speaking to distinguished members of parliament. And I'm still a student learning these processes, but I just want to share a few of the experiences. I would cite most of my examples from Africa, but I will also show that there is a problem that is global, so that perhaps it's not seen that Africa is the one that is lagging behind. Article 19 is an international human rights organization, just about 3 decades old. It was formed in 1987. And most people would know that its first kind of global work was to try and protect Salman Rushdie. So the author of Satanic Verses. trying to get him out of India after the fatwa was declared on him and get him space in other countries until he got to UK, where he's lived for many other years. So then Article 19 was largely an American organization. But out of that experience, it began tilting towards Europe and picked its stay in London. But one of the things Article 19 has been doing over the years is asking itself, where do we have gaps within international human rights law on issues of freedom of expression? And most recent, we've just been working with the Office of the High Commissioner for Human Rights on dealing with Article 20 of ICCPR, which is the article that requires states to prohibit incitement to hatred, violence, and discrimination. But ironically, it's the only article that they've not been any elaboration ever since. So states all over the world have appropriated that language and said, we are doing as instructed by ICCPR, which we are state party to. So we came up with a policy on incitement to violence, hatred, and discrimination, which begins to distinguish between different sets of speech and begins to understand when would you say that this speech has crossed the threshold to be that which ought to be proscribed. And out of that consultation with the Office of the High Commissioner, there is now what is called Rabat Action Plan for States, which I would request that the Commonwealth Parliamentary Association and the legislators here look at and begin to understand that prohibition of incitement is not equals to criminalization alone, that there are more to that we need to think about. But Article 19 had earlier also thought about the intersection between freedom of expression and national security many years ago. In the 90s, they came up with what has been dubbed the Johannesburg Principles, because we knew that national security is going to remain a critical concern. And because Article 19 of ICCPR, subsection 3, requires that there be some limitation on freedom of expression, and more so when it has issues to do with public order, national security, public morality, and public health. So yes, Article 19.3 requires that limitation, but as Professor Franz spoke today and Professor Honora O'Neill, the Baroness, yesterday, yes, that limitation is permitted, but when would it be proportional and necessary? So is it the least intrusive mechanism available for states, or is it the most intrusive that you are getting into? So that's the kind of work we do, but I want to begin by pointing at the understanding that we all now have come to understand that freedom of expression is a critical component of any human being. And most people who spoke yesterday and today have said, if we are all going to say we want to be democratic states, because I didn't hear anyone saying we are not interested in being a democratic state, regardless of where we come from, then there is a list of 5 ingredients. Yesterday, the Baroness talked about 3, but for her, it was order, rule of law, and then democracy can come in there. So all I'm doing today is to say, if you take democracy, this is how you can unpack it. And to unpack democracy, you need to have 1, effective participation of all citizens or all people in a given society. And 2, equality in voting. So there is just participation in daily governance issues, but equality in voting. But to have equality in voting, you need the 3rd thing, which is an informed electorate. And 4th, you need citizens to control the agenda of the country, which is the hardest thing, because once elected, leaders tend to say, to hell with number 1, which is effective participation. You elected us, give us time to discharge our mandate. And giving us time to discharge our mandate is equals to, we need not consult you anymore. We will come back when there is need to vote. And number 5 is fundamental freedoms. And this is where freedom of expression comes in. And with it is then the understanding that there are independent sources of information. Yes, government and state parties are going to be one of the sources of information, but not the only one. So how have we fared in understanding freedom of expression over time? I think one, why I'm putting freedom of expression here, the likes of senior people, Thomas Jefferson once said, information is the currency of any democracy. But have we had a situation where there is democratization without people and democratization without information within the Commonwealth? That's a question I leave to you. But if you understood freedom of expression to mean the right to seek, the right to receive, and the right to impart information and ideas, then you begin to see that it is a fundamental human right. It is necessary for individual self-fulfillment, self-realization, and autonomy. And it is also an empowerment right, that if I told you you have a right to vote, but I didn't give you information about all the candidates, how are you going to exercise that right to vote? So you begin to see that within freedom of expression as an empowerment right, there is a right to know, there is a right to speak, and there is a right to be heard. And therefore, it is important that we begin to think about this. But as an organization, we've traced that in the first 20 years of the existence of Article 19, there was progress, and we need to mark that there was an improvement to the extent to which freedom of expression was being realized globally and even in Africa. But in the last 5 or so years, there is recession, both in the developing and older economies and democracies. So this is not a challenge to only Africa. But it is keen to understand that while at the normative process, I think all countries have done pretty well, that they have constitutions that safeguard and guarantee freedom of expression. So most of them are quite clear there. Most countries have also ratified key international instruments that guarantee freedom of expression. But it would be sad to tell you that within the Commonwealth, as we speak, there are very few countries. I think out of the 54, 53 countries, there are only 22 countries that have comprehensive access to information laws. And that's where the problem begins to be. That while most, so this is just about 42% of the Commonwealth have comprehensive access to information laws. But all the countries continue to keep either publication of false news in their statute books, seditious libel, criminal defamation. And this begins to tell you that anybody who states something that might be contrary to the position that those in power want, they've not given you information, but they can still criminalize what you've said if it does not please them. All these laws, again, are maintained purely because they are an old colonial kind of a relic that hangs around. So for most countries that keep publication of false news, if you look at Kenya, Uganda, Zambia, Rwanda, and others, you would notice that that was left in their penal codes by the colonizers. And we've said those were bad laws, that's why we fought for independence. But we gladly keep them word for word, 50 plus years down the line. And that's a big challenge. So as we speak, I've said in Africa, on total, there are only 14 countries that have access to information laws. But among the 18 that are in the Commonwealth, only 6 have access to information laws. And I may just want to repeat it: Mozambique, Nigeria, Rwanda, Sierra Leone, South Africa, Uganda. So the rest, Botswana, Cameroon, Ghana, Kenya, Lesotho, Malawi, Mauritius, Namibia, Seychelles, Swaziland, Tanzania, and Zambia, there have been discussions on we will pass access to information laws. In every other review, they promise We are pro-transparency. We are pro-accountability. These laws are going to be passed, but they have not. So my sister here, you would know that Ghana promised it will be the first one in West Africa. At least now, if it has to pass, it might be the 6th, if it passes tomorrow. But that hasn't happened. Successive discussions have been there for the last 3 presidents. And the bill seems to get its way to cabinet and outside, but never gets to be passed. The same has happened to Kenya for the last 15 years. Discussions on the bill. The latest review that Ruth talked about in Geneva on the UPR, our Attorney General said it is before Parliament. This was said in the last review, which was 4.5 years ago. It is before Parliament. So it is before Parliament. But can Parliament then say, where is it exactly, so that it can move to the next step? Asia is also not doing very well. I think out of the 8 Commonwealth countries, you only have 4. So Bangladesh, India, Maldives, and Pakistan. But you have a bigger problem in the Pacific, because it's only Australia and New Zealand that have access to information laws. Even in Europe, there is one. Cyprus doesn't have an access to information law. And within the Caribbean and Americas, I think they've done very well, because there are 8 countries that have access to information laws. But what makes another thinking is that most of these Commonwealth countries keep criminal defamation in their books. Most. That is one thing that runs across. Most of them keep publication of false news. Most of them keep insult laws, insulting a foreign prince and the queen. And yes, they are independent. And they keep laws that say undermining the public authority. So a very vague thing. In Kenya, we have 2 bloggers who have, one has already been jailed for 2 years. Another one is, in fact, arrested this afternoon, undermining public authority. Yet we have had leaders saying, discuss with us, get in touch with us on what the problems are. And these bloggers are saying, you gave us phone numbers, Facebook accounts, and Twitter handles. When we try to reach you, you never respond. So they write in their blog, things are not moving properly. What do we do to get in touch with you? And police are then fast-tracked to say, take care, you're undermining public authority. So to re-echo, I think one Amartya Sen says, there is no country that has suffered from famine if it has a freedom of expression. Just because in one corner of the country, there will be excess food, and in one area there will be lack. Where there is information where that food is, people haven't died. If you notice people have died in your country because of famine, there is a high likelihood you don't have freedom of expression. So how do we move forward? The promise of stalled legal reforms that began in the 90s and have been muted, yes, is a critical thing we need to look at. The issue of limited media pluralism. There is still state-controlled broadcasters and media houses, very few individual or private media. And lastly, lack of political will to move from the rhetoric of transparency to actual transparency. If we get to do all that, then for sure, the instrumental power of freedom of expression would help the Commonwealth be democratic states and move forward to development. Thank you.